It's 8:28 p.m. on July 23rd, 2020. In the findings, conclusions, and recommendation of the United States Magistrate Judge Renee Harris Tolliver, in case number 3:19-CV-2280-K-BK. The judge says, quote, here, the facts as alleged by Krause clearly demonstrate a lack of subject matter jurisdiction in this court. Thus, granting leave to amend would be futile and cause needless delay. In the footnote, she references Erickson versus Pardue 551 US 89, 94, 2007, quoting, pro se pleadings are to be, quote, to be liberally construed, end quote, and, quote, held to less stringent standards than formal pleadings drafted by lawyers, end quote. I contend that Judge Harris Tolliver was the one who lacked jurisdiction. My original claim, my original proceeding, was requested for consideration under racketeer influenced and corrupt organizations. That is not appropriate for a civil consideration before a magistrate judge. She was the one who lacked subject matter jurisdiction. Additionally, the footnoted citation concerning liberally construed, as well as held to less stringent standards than formal pleadings drafted by lawyers. Even if it were to be determined that I should be held to a less stringent standard, I do not believe that justifies allowing for a judge or for the rules of the appropriate procedure to be held to less stringent standards. What I've shown is that I am repeatedly put on currents where I am triggered or compelled to some sort of ex parte proceeding. And as I said very specifically in the claim itself filed at the time, that my previous efforts had been subjected to derivative actions and that I was contesting the manner in which they had been treated by the Texas Supreme Court and was requesting a new trial under federal jurisdiction for consideration of constitutional violations by the Texas Supreme Court. There is indeed precedent and there is indeed a constitutional reason. Jurisdiction can be established in the federal district court if a state court has been determined to have been in violation of the constitution of the state and they have not taken appropriate remedy to address their own violations of their own constitution. As a matter of fact, such was cited in my first petition to the Supreme Court of the United States in both 2017 and in my second effort in 2018, before I even filed in the federal district court specifically in that manner. What I saw was each time my case would be kicked back as if every single time it was a matter of lack of jurisdiction, when it would appear over the time frame that there was a refusal to consider it within the appropriate jurisdiction, which was a criminal jurisdiction. We're talking about criminal charges. I was requesting assistance with filing a racketeer influence and corrupt organizations case, understanding I was representing myself pro se because up until that time I had been denied any legal redress. And that in the state of Texas there is no civil recourse for RICO. So these are constitutional matters. These are also procedural matters that would need to be discussed because if in fact there is no civil redress for RICO and there has been intentional manipulation in order to increase the risk or to artificially engage in aberrant practices because my case has been used as a derivative action and somebody wanted to be able to put it into a pipeline that could establish kickbacks later on based on me being continuously put through a filing process because of a refusal to address the actual charges at hand and to instead engage in some sort of illegal or unconstitutional manipulation of the judicial process to compel me to file again. That was the charges. And unfortunately, due to the way the judge Renee Harris Tolliver handled it, and then later Judge Ed Kinkead, where he says in his response, that um, the court prospectively certifies that any appeal of this action would not be taken in good faith. Taken by the court in good faith, or would not be taken, and so far as understanding, I had submitted it in good faith. This question or this challenge to the faith involved is also part of my allegations that my efforts have been used in derivative actions that are part of a kickback scheme that also is involved with a pattern of racketeering activity that includes criminal activities, as opposed to actually discussing matters of the specific jurisdiction at hand. Were I to have been acknowledged through the procedure that was outlined in the actual both rules of the criminal court procedure as well as the rules of the civil court procedure, then I would have already been acknowledged for having jurisdiction because I went through the appropriate process. And not only that, the specifics and the allegations about the abuse of the judicial process would have been handled because I have the competence to do that. But more than that is this in the response from Judge Irma Carrillo Ramirez that says, that discusses the concept of a complaint is frivolous when it, quote, lacks an arguable basis either in law or in fact, end quote. A claim lacks an arguable basis in law when it is, quote, based on indisputably meritless legal theory, end quote. A complaint fails to state a claim upon which relief may be granted when it fails to plead, quote, enough facts to state a claim to relief that is plausible on its face, end quote. I am more concerned with the fact that without addressing the merits of the actual claims that were presented, what instead I got were responses that had strategically identified case law references that I have tracked as part of this pattern of racketeering activity. Additionally, nowhere is there present anything concerning what the special order to which this refers is. And not only that, it says in her response that about suing the judge, suing the judges in their official versus individual capacity. Please read the original claim as it was presented. If you are concerned about whether I consider what they did to be an abuse of their ministerial duties, then also understand that I went through the process outlined by the local rules of the court, and it was the local rules of the court upon which they were being challenged, as is discussed in the book regarding the local rules of the court. So if you're presenting a handbook for what the local rules are, and then you want to put on the public electronic record a jurisdictional consideration that's abrogating the specific rules of the court while giving an appearance of adhering to the official federal rules of civil procedure, then the question becomes, under what authority are you doing so? And if it's coded into a secret order, then you've already, by the rules of the local court, identified yourself as engaging in derivative action connected to a criminal proceeding.